to Section 86 and 102 of RA 9165, or the Comprehensive Dangerous Drugs Act of 2002. So let's start off with Section 86. So Section 86 is all about the transfer, absorption, and integration of all operation units on illegal drugs into the PDEA and its transitory provisions. So to put in simple terms, all of the drug-related matters in the country will be transferred to PDEA, or the Philippine Drug Enforcement Agency. Since there are current agencies of the government that at that time that also deals with drug-related operations, such as the narcotics group of the PNP, the narcotics division of the NBI, and the customs narcotics interdiction unit. So those groups, organizations, or agencies will be removed or abolished, and all of the power that they are functioning will be transferred to PIDEA. However, they shall continue with the performance of their task as detail service with the PIDEA, which are subject to screening until such time that the organizational structure of the agency is fully operational and the number of graduates of the PIDEA Academy is sufficient to do the task themselves. So, next slide. So personnels that are under those agency have the right to be transferred to PIDEA or remain on their agency for the time being until they are being reassigned, with all of the reassigning and absorption of personnel, positions uh, similar in rank their positions similar in rank, salary, and other emoluments and privileges granted to their respective positions in their original mother agencies. It means that whatever benefits they are receiving in their mother agencies shall be the same when they are reassigned. So with all the reabsorption and integration of the different offices and units provided for in this section shall take effect uh, within 18 months from the effectivity of this act, provided that the personnel absorbed and on detailed service shall be given until 5 years to finally decide to join the PDEA. In terms of the NBI and PNP, they have their own roles or power to function on their own, but they shall not interfere or violate the provisions of the Act, making the PDEA the lead agency to all of the drug-related operations. Whenever there are issues about drugs, the PDEA should be the one to immediately handle it, but the NBI and PNP can also help by giving assistance. So that is all about the Section 86. So let's proceed to Section 87.
For Section 87, it is entitled Appropriations. So the amount necessary for the operation of the board and the PDEA shall be charged against the current year appropriations of the board to the National Drug Law Enforcement and Prevention Coordinating Center, the Narcotics Group of PNP, the Narcotic Division of NBI, and other drug abuse units of the different law enforcement agencies that is integrated into the PDEA in order to carry out the provisions of this Act. Thereafter, such gums as may be necessary for the continued implementation of this Act shall be included in the Annual General Appropriations Act. Next slide, please. So, all of the receipts derived from fees, fines, and other income authorized and imposed of this Act, including the 10% of all unclaimed and forfeited sweepstakes and lotto prizes, but not less than 12 million pesos per year from the PCSO, are hereby constituted as special account in the general fund or for the implementation of this Act. And no amount shall be disbursed to cover the operating expenses of the board and other concerned agencies, provided that at least 50% of all the funds shall be reserved for assistance to rehabilitation centers. Next slide. So the fine should be remitted to the board by the court imposing such fines within 30 days from the finality of its decision or orders. So the unclaimed and forfeited prices shall be turned over to the board by the PCSO within 30 days after these are collected and declared forfeited. So a portion of these funds generated by the PAGCOR in the amount of 5 million pesos a month shall be set aside for the purpose of establishing a drug rehabilitation centers in the country, and also for the maintenance and operations of these centers, provided that the said amount shall be taken from the 50% share of the national government in the income of PAGCOR. Also further, that the said amount shall automatically be remitted by PAGCOR to the board, and the amount shall in turn be disbursed by the Dangerous Drugs Board, subjected to the rules and regulations of the Commission on Audit. Next slide, please. That's all.
For the Section 88, Management of Funds under this Act, Annual Report with the Board and the PDEA. The Board shall manage the funds as it may deem proper for the attainment of the objectives of this Act. In addition to the periodic reports as it may be required under this Act, the Chairman of the Board shall submit to the President of the Philippines and to the presiding officers of both houses of Congress within 15 days from the opening of the regular session, an annual report on the dangerous drugs situation in the country, which shall include detailed accounts for the programs and projects undertaken, statistics on crimes related to the dangerous drugs, expenses incurred pursuant to the provision of this Act, recommended remedial legislation, if needed, and such other relevant facts as it may be deemed proper to cite. Meaning de is dapat na i-manage ng board ang funds accordingly para ma-attain nila ang goals ng sini nga act. In addition sa periodic reports naging required sa muni nga act, ang chairman of the board dapat mag-submit siya sa President of the Philippines and sa presiding officers ka both houses ng Congress. Within 15 days, halin sa opening ka regular session, ang tanan naging lawag to gina recommended siya mag-remedial legislation if needed ang iba nga relevant facts nga consider sa muni nga iupod sa site. That's all. Next slide, please.
Next is the Section 89 entitled Auditing the Accounts and Expenses of the Board and the PDEA. All accounts and expenses of the board and the PDEA shall be audited by the COA or its duly authorized representative. So, as to Section 89, the Commission on Audit will conduct formal examination or verification or its duly authorized representative sa tanan nga accounts and expenses sa board and the PDEA. So, there are mga
Okay, let's proceed to Article 11, which talks about the jurisdiction over dangerous drugs cases. So for the Section 90, it will give more focus sa jurisdiction. So it says here that the Supreme Court shall designate special courts from among the existing regional trial courts in each judicial region to exclusively try and hear cases involving violations of this act. So from the existing regional trial courts, these are the trial courts nga sa kanilang regions sa Philippines, and I think it has been discussed man sa mga previous sections sa Morning Republic Act by the other groups, so I will not give more emphasis on that. But from the existing regional trial courts, our Supreme Court will designate as special courts. So, special courts from the word itself, special, so naka-specialize siya to handle specific nga cases. So in this Republic Act, in this section, of course, this refers to the dangerous drugs cases. So ini nga courts will be specialized lang to handle, to try and hear mga dangerous drugs cases. So ang ilang nga ruling, ilang nga jurisdiction restricted lang. Kag also limited man ang ilang jurisdiction lang for the dangerous drugs cases. Let's proceed. The number of courts designated in each judicial region shall be based on the population and the number of cases pending in their respective jurisdiction. So, ang number of courts, the number of special courts, dapat proportional man siya sa number sa population kag number of cases pending in their respective jurisdiction to avoid man nga magakulang kag hindi handle properly ang number of cases kay tungod kulang sila sa number man sang courts. Okay, proceed. The DOJ shall designate special prosecutors to exclusively handle cases involving violations of this act. Since special court siya, restricted tanan-tanan sa dangerous drugs cases lang. So, ang Department of Justice shall designate man a special prosecutor. So, hindi lang siya prosecutor nga any kind of prosecutor lang. Dapat prosecutor nga naka-specialize man to handle dangerous drugs cases. The preliminary investigation of cases filed under this act shall be terminated within a period of 30 days from the date of their filing. So, preliminary investigation, amo na siya ang pag-collecta or pag-gather information nga or evidences nga makapamatuod nga ang isa ka suspected person really committed a crime. So, ang preliminary investigation kuno nga filed under this Republic Act shall be terminated after or within 30 days. So, probably a month. Within a month, dapat ma-terminate na ang preliminary investigation. Because I think this is also for the sole purpose man nga hindi gid bala magdugay sa pag-conduct ng preliminary investigation. When the preliminary investigation is conducted by a public prosecutor and a probable cause is established, the corresponding information shall be filed in court within 24 hours from the termination of this investigation. So if ang preliminary investigation ang nag-conduct sina is a public prosecutor kag may nakita na nga mga enough evidences nga nag-commit man gid crime ang suspected person, or enough na bala ang mga nag-gather nila ng information for the preliminary investigation. So, ma-terminate na siya ang preliminary investigation. I-stop na ang preliminary investigation. And from that, within 24 hours, dapat maka-file na sila sa corresponding information sa court. Ma-report na nila dapat ang probable cause na na-establish nila during the preliminary investigation if ang nag-conduct is ang public prosecutor. So lain naman siya if ang nag-conduct ng preliminary investigation ang judge. Kay if ang judge ang nag-conduct and there is a probable cause na nga na-establish, may enough nga information, evidences, ang mag-file sa corresponding information is not the judge pero ang proper nga prosecutor. Hindi ang judge pero ang proper prosecutor ang ma-file pero ang kinalain lang is lawig-lawig ang time sa pag-file sa corresponding information. So within 48 hours pa compare kay naya nga sang public prosecutor ang nag-conduct 24 hours lang. Diriya since judge ang nag-conduct pwede nga within 48 hours mag-file sang imo nga corresponding information. And the trial of the case under this section shall be finished by the court not later than 60 days from the date of the filing of the information. So, after sang nag-file ka mo sa mga necessary information, halin sa preliminary investigation, mga naging conduct ang trial of the case is within 60 days lang. So, it is within 2 months nga pagtry sang case. And the decision on said cases shall be rendered within a period of 15 days from the date of submission of the case for resolution. So, from the submission of the case after Senate within 15 days, dapat mag-obra sang decision and also a resolution if ano man gid ang judgment, if ano man gid ang ipataw nga penalty, if ano man gid ang pag-aatubangon ng mga sanctions sang suspected nga person. So it is within 15 days lang. And that's it for our section 90. Let's proceed to section 91.
Now let's tackle about the section 91, which
is all about the responsibility and liability of law enforcement agencies and other government officials and employees in testifying as prosecution witnesses in dangerous drugs cases. So, in summary, any member of law enforcement agencies or any other government official or employee who, without valid reason, fails to show up or refuses to appear as a witness for the prosecution in any proceedings involving violations of this act shall be punished by imprisonment for not less than 12 years and 1 day to 20 years and a fine of not less than 500,000 pesos as well as administrative liability. He or she may be subjected to administrative obligation in addition to the administrative liability imposed by his or her immediate superior and or the competent body. The member of the law enforcement agency shall not be transferred or reassigned to any other government office located in another territorial jurisdiction during the pendency of the case. However, the concerned member of the law enforcement agency or government employee may be transferred or reassigned for compelling reason. So this compelling reason, the immediate superior shall notify the court where the case is pending of the order to transfer or reassign within 24 hours from its approval. If the immediate superior fail to notify the court of such order to transfer or reassign, imprisonment of 2 months and 1 day to 6 years plus fine of 10,000 pesos to 50,000 pesos. In addition to that fine, there will be a perpetual absolute disqualification from public office. Now let's proceed to the section 92.
Next is the section 92, or the delay in bunchling in the prosecution of drug cases. Any government officer or employee tasked with the prosecution of drug-related cases under this act through patent laxity, for example, napakita katamaran sa ilang work, inexcusable neglect, or for example, ang employee nga naka-assign sa pagmonitor is hindi active sa mga pagmonitor sa mga litabo sa sulod sang court, or unreasonable delay. It means that the time taken to do something has been unwarranted or sobra nga nagka-cause ng unsuccessful nga prosecution or dismissal sa mga drug cases shall suffer the penalty of imprisonment ranging from 12 years and 1 day to 20 years without prejudice or judgment to his or her prosecution relating to the matter at hand of the revised penal code. So that's for the summary for section 92. Let's proceed to section 92.
For the section 93, it talks about the reclassification, addition, or removal of any drug from the list of dangerous drugs. So, ang may authority para mag-obra sang such revisions or changes is the board. When we say the board, this refers to the Dangerous Drugs Board, which is responsible for the policy making and programs about drug prevention and control. So sila ni ang may power, authority to reclassify, add, or remove a drug from the list of dangerous drugs. For the proceedings naman niya to reclassify or ang mga nag-initiate bala to reclassify, add, or remove a drug are the following. First is the PDEA, the DOH, or petition from any interested party, including the manufacturer, sa mo ng drug, medical society or association, a pharmacy association, a public interest group concerned with drug abuse, a national or local government agency, or even an individual citizen. So, pwede ni sila ka-initiate nga, ay, amo ni nga drug kinanglan to ni i-reclassify, or i-remove, or i-add. When a petition is received by the board, it shall immediately begin its own investigation of the drug. So if ang petition to, for example, a petition to reclassify a certain drug na receive na sang board, so immediately they will begin their own investigation sa amo nga drug if okay siya for reclassification or if kinanglan magi siya i-reclassify. The PDEA On the other hand, OSO may begin an investigation of a drug at any time based upon the information received from law enforcement laboratories, national and local law enforcement, and regulatory agencies or other sources of information. So, as compared sa board, nga kinahanglan immediately pag-receive sang petition, nag-start tayo sa ilang own investigation ang PDEA, they can start their investigation at any time. So the board, after notice and hearing, shall consider the following factors with respect to each substance proposed to be reclassified, added, or removed from control. So hindi na ni siya basta-basta lang nga pinagusto lang silang reclassify, add, or remove ng certain drug. So of course, may araman sila legal basis for this. So una-una is its actual or relative potential for abuse. B, next, scientific evidence of its pharmacological effect if known. C, the state of current scientific knowledge regarding the drug or other substance. So the state of current scientific knowledge. Current, so updated nga scientific knowledge kay if ang imo nga ginbasihan nga scientific knowledge medyo dugay-dugay na, of course it is outdated naman as well. So it is not that reliable para mangin basis. Letter D, its history and current pattern of abuse. Of course, makip track ka man if ang pattern of abuse amo lang man siya gyapon nga sa subong it is one of the drugs na commonly being abused by people, and proceed sa the scope, duration, and significance of abuse, risk to public health, and last one, whether the substance is an immediate precursor of a substance already controlled under this act. The board shall also take into accord the obligations and commitments to international treaties, conventions, and agreements to which the Philippines is signatory. Okay. Mag-proceed kita sa the Dangerous Drugs Board shall give notice to the general public of the public hearing of the reclassification, addition to, or removal from the list of any drug by publishing such notice in any newspaper of general circulation once a week for 2 weeks. So, kinahanglan man nila i-publicize if there are hearing for reclassifying, adding, or removal sang amo ning a certain drug. So, himuon ni nila once a week for 2 weeks. And lastly, the effect of such reclassification, addition, or removal shall be as follows. Letter A. In case a dangerous drug is reclassified as precursors and essential chemicals, the penalties for the violations of this act involving the two latter categories of drugs shall, in case of conviction, be imposed in all pending criminal prosecutions. So, in case nga ang isa ka certain dangerous drug na reclassify siya as a precursor and essential chemicals. So, ang penalties under sang violations nga paggamit sa precursor and essential chemicals, ipaga-impose ni siya sa all pending criminal nga prosecutions. So, it will be applied. B, in case of precursors and essential chemicals is reclassified as dangerous drug. So, sulit naman, ang precursor and essential chemicals, gin-reclassify sila as dangerous drugs. So, the penalties naman for this violation involving the precursors and essential chemicals, so hindi lang penalties for the use of the dangerous drugs, pero dalaman ang violations for using this as a precursors and essential chemicals. So, i-impose ni siya to all pending criminal prosecutions. For the letter C, in case of the addition of a new drug to the list of dangerous drugs and precursors and essential chemicals, no criminal liability involving the same under this act shall arise. Okay, so if may addition of a new drug, so wala siya danay in any criminal liabilities, kay of course wala pa danay publicized, hindi pa aware ang public nga ayala na-add na ni siya gali sa list of dangerous drugs, consider na ni siya gali as a dangerous drugs. So, wala danay sang criminal liability after sang addition sa amo nga drugs. But, after 15 days from the last publication of such notice, so after 15 days, if na-publicize na na-inform na ang public nga ini consider na ni siya as dangerous drug. So any person nga maga-commit man or magagamit man sa amo nga certain drug nga gindugang nila as dangerous drugs will be held liable sa mapinaltihan na. And then, in case of removal of a drug from the list of dangerous drugs and precursors and essential chemicals, all persons convicted and or detained for the use and or possession of such a drug shall be automatically released, and all pending criminal prosecution involving such a drug under this act shall be forthwith be dismissed. So, in case naman niya sang removal of a certain drug from the list of dangerous drugs. So tanan-tanan ng mga tawo nga na-convict tungod sa use ng amo nga certain drug will be released. Siyempre buyan sila kay hindi na sila liable or hindi na sila mapenaltihan kay tungod gani na ginhukas sa dangerous drugs, hindi na consider dangerous drugs ang nagamit nila nga certain drug. And of course, ang mga criminal prosecution nga pending regarding sa use ng amo nga certain drug will be cancelled cancel or dismiss. And lastly, the board shall within 5 days from the date of its promulgation submit to Congress a detailed classification, addition, or removal of any drug from the list of dangerous drugs. So the board will be the one responsible for submitting a detailed reclassification, addition, or removal ng drug or a new list of dangerous drugs sa Congress after its promulgation. So that's it for Section 93. Proceed kita for Section 94.
For the Section 94, implementing rules and regulations, the present board, in consultation with the DOH, DILG, DOJ, DepEd, DSWD, DOLE, PNP, NBI, PAGCOR, and the PCSO and all other concerned government agencies shall promulgate within 60 days the implementing rules and regulations that shall be necessary to implement the provisions of this act. Ang members ng board sa ngamuto nga time upod sa DOH ang tanan nga ginpanglawag gina ang tanan nga ng concerned government agencies kinanglan nga i-promulgate ang rules and regulations within 60 days. That's all for Section 94.
Now let's proceed to Section 95, which is the Congressional Oversight Committee. So this section states that there should be Congressional Oversight Committee, which is composed of 7 members from the Senate, which will be appointed by the Senate President with at least 2 senators that would represent the minority, and 7 members from the House of Representatives, which shall be appointed by the Speaker with at least 2 members that would represent the minority. So the committee shall be headed by the respective chairpersons of the Senate Committee on Public Order and Illegal Drugs and the House of Representatives Committee on Dangerous Drugs for that Congressional Oversight Committee. That's it for Section 95.
For Section 96, it talks about the powers and functions of the Oversight Committee. So, in this section, these are the following functions and powers of the Oversight Committee. First is to set the guidelines and overall framework to monitor and ensure the proper implementation of this act. Next is to ensure transparency and require submission of reports from government agencies concerned on the conduct of programs, projects, and policies relating to the implementation of this act. Next is to approve the budget for the programs of the Oversight Committee on Dangerous Drugs and all disbursements therefrom, including compensation of all personnel. Next is to submit periodic reports to the President of the Philippines and Congress on the implementation of the provisions of this act, and also to determine inherent weaknesses in the law and recommend the necessary remedial legislation or executive measures. And lastly, to perform such other duties, functions, and responsibilities as may be necessary to effectively attain the objectives of this act. So, in conclusion, they are to conclude. They are they have the power or the authority to investigate the subject within the committee's legislative jurisdiction, as well as any matter within the jurisdiction of other standing house committees. They serve as the governing body in the project, or in this case, the act itself, and will provide direction, guidance, and leadership in ensuring the effective implementation of the goals and purpose of the act wants to do. So that is all for Section 96.
Now let's go to the section 97 titled Adoption of Committee Rules and Regulations and Funding. So the Oversight Committee on Dangerous Drugs shall adopt its internal rules of procedure, conduct hearings, and receive testimonies, reports, and technical advice. Also, the Oversight Committee on Dangerous Drugs shall be assisted by a secretariat to be composed by personnel who may be seconded from the state and the House of Representatives. Next, to carry out the powers and functions of the Oversight Committee on Dangerous Drugs, so there is an initial sum of 25 million pesos that shall be charged against the current appropriations of the Senate. And lastly, the Oversight Committee on Dangerous Drugs shall exist for a period of 10 years from the effectivity of this act. Next slide, please. Next, let's go to the Section 98, the limited applicability of the revised penal code. So the provisions of the revised penal code, Act number 3814 shall not apply to the provisions of this act, except in the case of minor offenders. So where the offender is minor and the penalty for acts is punishable by life imprisonment to death.
Okay, so let's tackle about the section 99, which is the separability clause. If for any reason, any section or provision of this act or any portion thereof or the application of such section, provision, or portion thereof to any person, group, or circumstance is declared invalid or unconstitutional, the remainder of this act shall not be affected by such declaration and shall remain in force and effect. Okay, let's proceed to section 100.
So for the section 100 are the repealing clause. Republic Act number 6425 as amended is hereby repealed, and all other laws, administrative orders, rules and regulations or parts thereof inconsistent with the provision of this act are hereby repealed or modified accordingly. So in section 100, ang Republic Act number 6425 are the Dangerous Drugs Act of 1972 are repealed by the RA 9165 since the law mandates the Dangerous Drugs Board to be the policy and strategy making body that plans and formulates programs on drug prevention and control. Kag ang tanan nga inconsistent laws, administrative orders, rules and regulations sa sa Republic Act 91 number 9165 are revoked or changed consistently. So that's all for the section 100. Let's proceed to section 101.
So for the section 101, it talks about the amending clause wherein Republic Act number 7659 is hereby amended accordingly. So the amendment clause stipulates the conditions for changing the terms of an agreement. So Republic Act number 7659 is hereby amended accordingly. So Republic Act 7659 talks about the death penalty for such heinous crimes. Since it is being amended on this act, it means that crimes involving drugs stipulated on this act cannot be imposed to penalize resorting to death. So that is all for the amending clause. Now let's proceed to section 102.
For Section 102, effectivity, this act shall take effect 15 days upon its publication in at least 2 national newspapers of general circulation. Ang muni nga act ma-take effect siya after 15 days ka publication sa at least 2 ka national newspaper ka general circulation. That's all for Section 102.
So that is all for our discussion regarding RA 9165 for sections 86 to 102.